Versus Lucille Slater.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Slater, who is approaching. Please state your name for the record, ma'am.
Lucille Slater.
Thank you.
Thank you, Your Honor. Today is the date and time set for sentencing. I have had the opportunity to review the PSIR with Ms. Slater. We only have one brief correction, and that is on page 2 under the summary. It states that she pled no contest to this charge on the date of her pretrial hearing on the 17th. That is correct that it occurred on the 17th, but that was the date of her final settlement conference. That is the only correction we have, Your Honor. And as to the recommendation, I do believe it to be fair recommendation, and I would ultimately ask the court to adopt it. Ms. Slater presents to the court, she's 76 years old with no prior convictions of any kind. This is quite literally her first rodeo in this situation. She has, throughout my representation of her, taken this matter very seriously and has, to me, shown a lot of remorse for her actions on that day. She, prior to this incident, she had worked at this position for almost 7 years, and to my knowledge, had no other prior incidents of this kind. This is her first interaction with the criminal justice system. She has expressed much remorse to me. To my understanding, she has complied with her bond to the T and has appeared in person for all her court dates. I would ask that the court adopt this recommendation.
Ma'am, is there anything you want to say before the court imposes sentence?
No.
Buckle up, guys. Today we're stepping inside a courtroom where a quiet sentencing slowly turns into something far heavier. At first glance, this case seems straightforward. A 76-year-old defendant, no prior record, and a defense asking for leniency. The tone is calm, almost procedural, but beneath that calm, something feels unresolved. This opening lays the groundwork for what's about to unfold, and trust me, it doesn't stay quiet for long.
No.
Your Honor, I'm sorry to interrupt.
Yes, I will get to that in just a moment. I was aware.
No, Your Honor.
All right. You guys are going to need to have a seat here. Right. Please, somebody. Sorry. I understand there's a victim's impact statement.
Yes, Your Honor.
This is where the atmosphere begins to shift. The defense finishes, and the court prepares to hear from the victims. You can feel the pause, that moment where everyone knows the emotional weight is about to enter the room. The judge calls the parents forward, and suddenly this case stops being about paperwork and recommendations. It becomes about real people, real consequences, and a child at the center of it all.
Yes, Your Honor. The minor child's mother and father is Julie and Ryan Franks. They are brothers.
Julie and Ryan.
Julie and Ryan.
Got it. All right. Hello.
Hi, Your Honor.
Could you state your names for the record?
Yeah, Julie Franks.
Ryan Franks.
All right, thank you. And I'll need you to take your hands out of your pockets if you would. Thank you. All right, I think we're all set now. Go ahead.
Thank you, Your Honor. Thank you for giving us the opportunity to speak today. We are here as the parents of a 7-year-old little girl who was physically grabbed and yelled at by Ms. Slater at school, a place where she should have felt completely safe. That day changed our daughter. Since then, Natalie has struggled with anxiety and fear. She often asks questions no child should have to ask. Things like, why did that happen? And will that happen to me again? It has been incredibly painful as her parents to watch her confidence fade and to see her question the trust she used to have in the adults around her. We spent months trying to rebuild her sense of safety.
This is the moment that hits hardest early on. The parents describe what happened to their 7-year-old daughter and how that single incident changed her sense of safety forever. Anxiety, fear, and confusion replaced trust. You can hear the pain in their words as they explain how their child now asks questions no child should ever have to ask. The courtroom isn't just listening anymore, it's absorbing the damage.
Built her sense of safety through reassurance, through love, but this incident left a mark. It's something she carries and will carry with her forever, and something we, as her parents, will never forget. What's been equally hard is seeing how little remorse Miss Slater has shown. When police reached out to get her statement, she hung up on them and blocked their number. That forced us to move forward and press charges. When officers went to her home, she
The emotion
refused.
turns into frustration here. The parents don't just talk about the incident, they talk about what happened after. They describe ignored calls, blocked numbers, and a refusal to engage with police. To them, this silence feels like indifference. And that's when the narrative sharpens. This isn't only about what happened to their child, but about accountability that, in their eyes, never
At her
came.
home, she refused to answer the door even though they could clearly hear people inside. Those actions speak volumes. They show a complete lack of accountability, of remorse, and of understanding of the harm she caused. We truly believe that if given the opportunity, she could have hurt another child. We understand that everyone makes mistakes, but when an adult's action causes emotional and physical harm to a child, that can't be taken lightly. Our greatest hope is that the court ensures that this individual is not in a position to work.
This
or be
part is deceptively quiet, but it's critical. The defense insists the defendant is remorseful. Yet when the judge asks her directly to speak, she says nothing. That silence lands heavily in the room. No apology, no acknowledgement, just a pause that feels louder than words. From here on, everything changes because the court begins to question whether remorse exists at
to
all.
work or be responsible for children. No family should have to go through what ours has. We're speaking today, not just for our daughter, but for every child who deserves to feel safe and protected at school. That's all any parents want, to know that their child is safe when they walk through those doors. Thank you, Your Honor, for listening to our story and for considering the impact this has had on our daughter and our family.
Thank you for coming down. All right. All right. Is there anything she wants to say now?
Just very briefly, Your Honor, I do want to mention Ms. Slater has taken accountability and has expressed remorse in this matter. Of course, to me, and
This
of
is
course,
where the judge's tone shifts from neutral to deeply personal. He reflects on the parents standing before him and the child who couldn't be there. He acknowledges the legal explanations, but something is clearly bothering him. This isn't just about rules anymore. It's about empathy. You can sense that the judge is preparing to address something far bigger than sentencing guidelines.
Of course, to me, and of course, by entering a plea in this case, she takes accountability for what actions did occur, and she is remorseful. I can say that through my many discussions with Ms. Slater, and she does take accountability for what did occur. And I do believe she is remorseful, and her choice not to give a voluntary statement to the police, I believe, was based on the advice she had received through counsel and other means. That being said, she is remorseful for her actions and has taken accountability.
Anything you want to say?
No, Your Honor.
Okay. So I get the notion that prior to anything happening, and I can understand why it might confuse the Franks, or they're not appreciating that she may have been told she was a union employee or through lawyers not to say anything, not to have contact. So I get that, and that might be, one might expect as a parent that somebody might act a little bit differently. But I get why somebody would act. I am, however, a bit concerned that as we get here today, as we are here today, that there's this little girl, and something happened to her. And standing there in her stead are her parents who have taken their time to come down to let the court know.
This is the emotional core of the entire case. The judge reveals he gave the defendant 2 chances to simply say, "I'm sorry," to the parents. Twice, she said nothing. He explains why that mattered, why an apology could have helped a child heal. This isn't anger, it's disappointment. And in this moment, the courtroom realizes that silence can sometimes do more damage than the original act.
Basically, the effect that this has had on their child, which, yes, spoken like true parents, but also moms will do this. They don't express necessarily the impact that it's had on them, but they talk about what's happened to their child. And I did something different because I was told prior to this hearing and in reading the report that there wasn't a sense of remorse for what had happened. Even if done accidental, even if done out of a misapplied sense of how to have this child say. They were people saying, well, she's not really showing remorse. She didn't really care what happened to this child. And where I did something different, because the staff here knows how I typically will handle these situations when I have impact statements. You would have sat down. They would have spoken to me, and then you would come back up. But I would not have addressed you prior to Frank speaking. Do it that way pretty much every time. I did it differently for a reason today. Because I was at least going to give you maybe 2 opportunities to look that little girl's parents in the eyes. And whether or not you meant to do what you did, just to tell them you're sorry. Because that's their baby girl. And I gave you those 2 opportunities the first time. Nothing. You sat down, you heard Mom speak, came back up, asked you again, and nothing. I don't know how you do that. It puts into perspective for this court what happened that day. Because I sat there and I thought to myself, well, if somebody who works for the school, things can get out of control, they can do this, but no, it's just like I told the person before you. I'm not sure that you've got a right, except for the purpose for safety reasons or other necessary reasons, to put your hands on somebody else's child. You can't do it. And then, if you lose your mind for a minute, for whatever the reason, and you do, then quite frankly, you take responsibility for it. You say, I shouldn't have done it. And if you can't apologize to the little person, you apologize to her parents. So at least her parents can go and say, hey, look, she apologized. This is her version of it. She didn't mean it. And they can sort of move forward with that lesson that they're entrusted to teach their child. But you can't even do that.
If I may, Your Honor, My client and I have had to discuss the no contact order multiple times, partially for that reason. I have had to remind her that she is under a court order not to reach out to the Franks and apologize, not just the minor child, but as the adults. In pursuant to that court order, she has not had any contact with them whatsoever, good, bad, or indifferent. And she is sorry to the Franks.
But
has
today,
expressed that.
today, Miss Pate, that's what I'm talking about. I get everything maybe before they got here today. But for God's sakes, there are parents here that are talking about what trauma has happened to their child at your client's hands. And she didn't even have to look at him. She could have told me, as people do, that she's sorry, but nothing.
But I am sorry, sir.
And Your Honor, I would like to reiterate, and not to speak out of turn, Ms. Slater is very nervous about being in front of Your Honor and in this court today. And I do reiterate that she is 76 years old and this is her first time coming to court. To my knowledge, for anything, but I know for a fact for something like this, she has expressed her remorse to me multiple times. I've had to remind her of the no contact order for that purpose. And I do understand what the court is saying and her not saying anything today. However, I can represent to the court that she has expressed remorse to me about this incident. And she has wished she could apologize privately for the no contact.
That's all fine and dandy. But how do they know that to say that to their little girl? They don't.
It's unfortunately one of those situations with our system, which of course there's very much a need for no
This
contact.
is not, no, today I get beforehand. But today I gave her 2 opportunities. She doesn't have to even look at him to just say she's sorry, and she didn't.
She did, Your Honor. Right. I just want to make sure the court heard. I'm sorry. She said it a little quiet.
Oh, I heard it. Too late. Is that said, because at this point, I don't know if that's said because she's really sorry and remorseful about what's happened to this little girl, or if she's only saying that because I pointed out that she didn't.
Your Honor, what I can say is before today, she's expressed remorse to me. And as Your Honor knows, I do represent a lot of clients, and quite candidly, there are a lot of clients who don't. And unfortunately, I don't have the opportunity to say that about them. But in Ms. Slater's case, I can say that. We've had several meetings outside of court as well, in person in my office, both to discuss this case. And quite candidly, since the beginning, Ms. Slater has both been apologetic, but also wanted to take accountability. I believe one of her words to me, our in-person meeting when we were reviewing the footage of the incident in my office, was, I believe I deserve some sort of punishment, and I want to be sorry and move this behind me, and I know I can't reach out to the parents. And of course, at that time, I reiterated, no, absolutely not. Do not reach out to the parents. You're under the no contact order.
I have to give the Franks credit, because I think that had been my daughter, I would have lost my darn mind. I'm not even going to pretend I would do something different than that. But that's me. It's the sentence of the court. I'm going to place you on 18 months prosecuted deferred sentence, and I'm going to let you know that in my mind that I wasn't sure whether or not I was even going to allow the deferred. I looked at your lack of record and decided that I would indeed give that to you. But initially my first thought was I wasn't going to give you the benefit of even being part of that program. But I will place you on that program for a period of 18 months. $455 fines and costs, $540 probation oversight fees. When can that be paid?
Your Honor, my client says she can pay $200 today and is asking for a payment plan as to the rest.
How much can she pay per month? Well, no, I'm gonna make it $200. She's to pay by December 22nd, 2025, and then a payment plan as arranged by probation.
All right,
There's-
guys, everything comes together here. The defense tries to explain the silence, but the judge isn't convinced. He delivers the sentence, lays out strict conditions, and then drops the shock, jail time effective immediately. The room goes still. This case ends not with chaos, but with a hard lesson about responsibility and protection. If this breakdown helped you understand what really happened, make sure to like the video, subscribe to the channel, and we'll see you in the next video.
There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an anger management program as directed by probation. I am ordering no contact with Julie, Ryan, Natalie Franks, directly or indirect. I'm ordering that there be no working with and or around any minor children. There is to be no assaultive, threatening, or intimidating behavior. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. I will set a review hearing on this case that is to be held May 12th, 2027 at 9 a.m. With reference to jail time, ma'am, I have taken into account who you are and what I could see on this paper. I've taken into account the things that I've said on the record. And I've taken into account, as I did with the deferred sentence, the fact a lack of record for your entire life, at least as we see it here. But you can't grab someone's child. You just can't.
Understood.
So it's 90 days in Washtenaw County Jail. Defendant is to serve 15 days. The balance of that time will be suspended. Defendant is remanded.
Your Honor, I know Your Honor has issued a ruling, but may I make a request that her to be able to turn herself in a few days? Her husband does have some severe health issues, and I'm just asking, given...
I need medical regarding that, and I will consider it, but right now she's going. Okay.